two each of the verdict forms, two for defense, two for state. Two sets of instructions, two for state, two for defense. We have 6 left here. Did I have one if you want to manage? All right, there's 5 here, so that's 6 for the jury. All right, you've given your warnings, everything to Alice, you have them? The warnings this time. Ready to go?
Yes, sir.
Bring up the jury. Jury entering. All right, counsel, be seated. Welcome back, members of the jury. As I indicated before the lunch break, the evidence is now all in. So what we're going to do at this time is I'm going to give your legal instructions to you and also have the attorneys, or give the attorneys the opportunity to make a closing argument. You each should have a set of jury instructions either on your seat or in front of you, with a few words of explanation with regard to jury instructions. Most of these instructions I'm going to give to you now before the attorneys actually make their closing arguments. There's a final instruction at the end on page 8 that I give to you after the attorneys have made their closing arguments. As they go through the instructions, you will see I get to a point where I begin to read from a verdict form. Do not look for your copy of the verdict form. You do not have a copy of the verdict form currently. I have the original here. I'll obviously send it back with you into the jury room for your use during deliberations. But when I begin to read from it, don't look for it because you don't have it. I indicated at the beginning in my preliminary instructions that I'm required to publish these instructions here in open court, which means I'm literally going to read these instructions to you at this time. It's your choice. You can simply listen to me read, or you can read along with me, but I'm going to publish the instructions at this time verbatim. Jury instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charge. Melanie Eam, the defendant in this case, has been accused of the crime of second-degree murder. When there are lesser-included crimes, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser-included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser-included crime. A lesser crime included in the definition of second-degree murder is manslaughter. Introduction to homicide. In this case, Melanie Eam is accused of second-degree murder. Second-degree murder includes the lesser crime of manslaughter, which is unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find James Berry was killed by Melanie Eam, you will next then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Melanie Eam may be found guilty of second-degree murder or any lesser included crime. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Berry is dead. 2, the death was caused by the criminal act of Melanie Eam. 3, there was an unlawful killing of James Berry by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done with ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Melanie Eam did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Melanie Eam was in fact so provoked and did not cool off before she committed the act that caused the death of James Berry. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should not find her guilty of second-degree murder, but should instead consider whether she is guilty of some lesser included crime. If you find the defendant guilty of second-degree murder, you must next determine whether, at the time of committing the second-degree murder, she carried, concealed, used, threatened to use, or attempted to use a weapon. If you find that she carried, concealed, used, threatened to use, or attempted to use a weapon, you should find her guilty of second-degree murder while in possession of a weapon. If not, you should find her guilty only of second-degree murder. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Berry is dead. 2, Melanie Eam intentionally committed an act or acts that caused the death of James Berry. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find the defendant guilty of manslaughter, you must next determine whether, at the time of committing the manslaughter, she carried, concealed, used, threatened to use, or attempted to use a weapon. If you find that she carried, concealed, used, threatened to use, or attempted to use a weapon, you should find her guilty of manslaughter while in possession of a weapon. If not, you should find her guilty only of manslaughter. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment for each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an active memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 7. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the following circumstances, including but not limited to: 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that you must follow in order to return a lawful verdict. The numbering here is a little off, so I'm going to go 1, 2. The 2 is going to be 1. 1, you must follow the law as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and these instructions. 3, this case must be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each of you must agree to the same verdict. 7, the jury is not to discuss any question the juror wrote that is not asked by the court and must not hold that against either party. 9, your verdict must not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law containing these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged in the information or of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense, which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Verdict. We, the jury, find as follows. We find the defendant guilty of second-degree murder, as contained in the information. If you find the defendant guilty of second-degree murder, you must next answer the following question. Did the state prove beyond a reasonable doubt that the defendant carried, concealed, used, threatened to use, or attempted to use a weapon, yes or no? Guilty of manslaughter, a lesser included offense. If you find the defendant guilty of manslaughter, you must next answer the following question. Did the state prove beyond a reasonable doubt that the defendant carried, concealed, used, threatened to use, or attempted to use a weapon, yes or no? Not guilty. So say we all. This blank day of September 2018 in West Palm Beach, Florida, Palm Beach County, Florida, to be signed by the jury foreperson. Those are the written instructions I have for you at this time. The attorneys will now have an opportunity to make a closing argument. I will remind you of what I told you at the beginning of the case. A closing argument is not evidence. It is simply the attorney's opportunity to tell you what they believe the evidence has shown, or again, perhaps from their perspective, not shown in the case. Both sides will have equal time for their closing argument. However, the state has the right to reserve a portion of its closing for rebuttal, so in essence, the state goes twice. Who's on the primary?
I am, Your Honor.
Scott, floor is yours.
Thank you. Okay, please, board counsel at this time. Members of the jury, what is the power of love? The tragedy that ultimately led to the slaughter of James Berry in this case by his girlfriend, the defendant that sits before you, is nothing new. The circumstances as old as time, a woman rebuffed by the person that she loved, overcome by the emotion of her life, did something terrible. Took a life, took a young man out of this world. This case is about love gone awry, the love of this defendant for James Berry that he pulled away from her, which she couldn't accept. She was a woman scorned on November the 17th, 2016. In 1697, William Congreve penned the immortal line, "Heaven has no rage like love to hatred turned, nor hell a fury like a woman scorned." And nothing could be more true in this case, where that defendant, Hellraiser, self-proclaimed, rejected by the person, and unfortunately turned his gaming fantasy into her reality, that he burned in hell. November the 17th, 2016, having been broken up online through a chat for which you have the telephone and the chat to which we'll go through, and a last-ditch effort to reconcile it, that defendant traveled to the home of James Berry, and she stabbed and killed him. No one else. And in this case, she's charged with second-degree murder, an instruction that you have in your packet. I'd like to address the elements of second-degree murder at this time. Now, you'll see that there are 3 elements to prove the crime of second-degree murder. 1, James Berry is dead. There's not going to be any dispute about that. You've seen the evidence. You've heard the medical examiner. James Berry is no longer